Good morning, students. Welcome to UPSC Preplab. This is Dhanunjay Reddy coming out with previous year question analysis of prelims subject of polity. So far we have done the previous year questions of 2025, 24, and today we are discussing the previous year questions of 2023 prelims. We have also already done 2026 also. So 2026, 25, 24 we have completed, and in this we are going to look at the beauty of the questions that have been asked in 2023. Now, as I always say, if you want to crack UPSC prelims, the major goal or the major mantra will be doing previous year questions. So let's have a look at how the questions have been asked, what is the nature of the questions, how far the difficulty level is there, and how to prepare for the upcoming examination. This is what I wanted to say. Now, before going further in this matter, let us also have a look at it. So this is our code, UPSC Preplab. UPSC preparation, if you are preparing it, you can use my code Reddy, and you can avail all these services nearly at free of cost, completely at free of cost. You have to pay just ₹1 for this for registration charges. Live NCERT, all the NCERTs are going to be covered by the expert faculty in this UPSC Preplab, along with foundation classes, learn from civil servants, where there will be civil servants who will be dealing with the subject matters, as well as how to prepare for your exam, complete test series and notes, and mains courses by officers. So UPSC preparation, you can just have a login into this by using my code Reddy. You can join it. So this is the first thing that I wanted to say before going into today's class. So let's start discussing about the subject matter. So polity, previous year questions 2023. Let's have an decent analysis on this. So whenever we prepare, ladies and gentlemen, one of the most important thing that you should understand is what are the areas that questions are being asked from? What are the major focus areas that UPSC is asking the questions from? This is the first thing that everyone should know. And second thing that we should know is how to prepare for the next exam. How to prepare for the next exam. So by looking at our previous year questions, we can do that thing. So let's start with our normal discussion. If you look at it, the first question is on fundamental rights. In essence, what does due process of law mean? Now, from where this question was asked, that is the first thing that you have to understand. From where did they ask this question? Due process of law. And there is one more thing that is called procedure established by law. According to Article 20 of Indian Constitution, there shall be right to you have right against conviction in certain offences. No person can be arrested or detained except according to the procedure established by law. This is what the article or fundamental right says. So procedure established by law is the term used in the Constitution. Now, what does you mean by due process of law? This is mentioning or this is questioning whether the law itself is correct or not. So whether the law itself is correct or not, which doesn't just speak about procedures, it discusses about the enactment itself. Take for example, in the olden days, the law was made by the king. What the king says, if you are very close to the king for the same offense which was done by a normal person, he will give less amount of punishment. So punishment varies from relative to relative of the king. But is this justice? That is not justice. Law should be applied equally to everyone. So sometimes law itself can be wrong. So questioning the enactment of the law or the law itself is and upholding that law itself is known as due process of law. So this speaks about the principles of natural justice. Naturally, the law has to be correct. Naturally, the law has to be correct. Leave about the procedure. First, look at whether the law established itself is correct or wrong in the first instance. This is the most important thing. So it speaks about the principles of natural justice, which is a very moderate question and which is very easy question, by the way, because anyone who has attended our classes, we have discussed this. Due process of law is nothing but procedure of natural justice. So it appears to be naturally correct, that has to be correct in this segment. That has to be correct in this segment. So this is first question, ladies and gentlemen, that everyone has to understand. Let's look at the second question. Consider the following statements. In India, prisons are managed by state governments with their own rules and regulations on day-to-day affairs. So what they are saying, in India, prisons are managed by state governments. So this is the subjects. So whether this is an union list, state list, or concurrent list. This is what the question is. It is clearly saying that prisons are managed by state governments. Yes, prisons comes under state list, means that is state government's management. And they have their own rules and regulations and day-to-day administration of provisions. In India, prisons are governed by the Prisons Act 1894, which is expressly kept this subject of prisons under the provincial governments. Is expressly kept under the control of provincial governments, and they are asking which is of the following statements of correct statements here. Which of the following statements of correct statements here? So have a look at it. Have a look at it. In India, prisons are governed by Prisons Act 1894. In India, prisons are governed by Prisons Act 1894. So, prisons is a state subject. When it is a state subject, when it is a state subject, when it is a state subject, when it is under the state government, it is natural that it will be under the control of provincial governments. So this is under the list of state subjects. State subject means provinces. So both the statements are correct and correct explanation. Both the statements are correct and correct explanation. So which of the following statements is correct here? Both are correct. Why? As prisons are under the state subject or provincial subject, you have the control of state legislatures. So both statement 1 and 2 are correct, and statement 2 is the correct explanation of statement 1, which is a very simple thing because statement 2 is reiterating the point of statement 1 here. Reiterating the point of statement 1 here. This is the thing that we need to understand. Moving further, which of the following statements best reflects the chief purpose of constitution of a country? Why should we have the constitution of the country in the first place? What is the need to have constitution? It determines the objectives of making of necessary laws. It enables the creation of public offices and government. It defines and limits the powers of government. Now look at this. Why should we have constitution? The philosophy of constitution is mentioned as constitutionalism. This is constitutionalism. What is the philosophy of constitution? The philosophy of constitution is rule of law. And the rule of law says that you should not have all powers vested in one center. Power should be divided so that there will be no concentration of powers and thereby rule of law can be upheld. So constitutionalism limits government because government is subjected to questions of the legislature as well as the judiciary if they are doing something wrong. So whenever government is not given that complete control, not having this monarchical control, that is the main goal of constitutionalism. So constitutionalism speaks about rule of law. Rule of law will be upheld when you have limited powers. Hence, government will be regulated or limited by constitutionalism. By constitutionalism. So it defines and limits the powers of government. It defines and limits the powers of government. So the answer is C here. The answer is C. Going further, in India, which of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of fundamental rights? So which of the following has been enacted to overcome judicial interpretations of fundamental rights? So fundamental rights, you have versus constitutional amendments versus DPSPs. It should be understood that in India, right from the beginning, there has been a debate between whether fundamental rights precede over the directive principles of state policy, or directive principle of state policy has higher powers than the so-called fundamental rights. So this was a subject matter of question right from the time of independence, because immediately after we have established these notions of constitution, what has done the then government of Jawaharlal Nehru? They have passed the so-called land reforms. Now, why they have passed land reforms? Because there was concentration of wealth in the hands of the so-called zemindars, mahalwars, landlords. To redistribute that land to the landless poor according to Article 39 of Directive Principles of State Policy, they have done this provision. So Article 1 has discussed, Constitutional Amendment Act 1 was made, through which they have introduced ninth schedule to the Indian Constitution, and they said that judicial interpretations of fundamental rights can be curtailed through this. So the first Constitutional Amendment Act introduced ninth schedule to the Indian Constitution, and ninth schedule to the Indian Constitution limited the powers of the judiciary not to enter into those items which are under the ninth schedule. So judicial interpretations, this was first constitutional amendment. Not only this, even during the times of Srimati Indira Gandhi, through 42nd Constitutional Amendment Act 1976, Srimati Indira Gandhi also has curtailed the provisions of judicial interpretation. Curtailed the provisions of judicial interpretation. We all know that 42nd Constitutional Amendment Act is called as mini constitution in India. So both the statements are correct here. First Constitutional Amendment Act and 42nd Constitutional Amendment Act, both are correct. So majority of the students kept 1, majority of the students kept B. But what is the official answer of UPSC? Officially, UPSC has cancelled this question. Why they have cancelled? Because 1 and 2 are correct statements. 1 and 2 are correct statements for this. UPSC officially has cancelled this question. 1 and 2 are correct here. Next, moving further. Consider the following organizations and bodies in India. Very, very simple question. They are asking about institutions. The National Commission for Backward Classes, National Commission for Human Rights, the National Law Commission, National Consumer Dispute Redressal Commission. National Consumer Dispute Redressal Commission. Now they are asking how many of the above are constitutional bodies. How many of the above are constitutional bodies? Have a look at it. National Commission for Backward Classes, NCBCs. Look at Article 338, 338A, 338B. National Commission for SCs, STs and BCs. So first statement is absolutely correct here. National Commission for Backward Classes is a constitutional body, whereas National Human Rights Commission is a statutory body. National Law Commission is a statutory body. It is neither a constitutional body nor statutory body. National Consumer Dispute Redressal Commission is a statutory body. So this is a very simple question. Just by knowing the provisions of constitution, you'll be knowing this. So what are the constitutional bodies? Only one is the constitutional body. So major constitutional bodies in India is the bodies that are mentioned in the so-called articles of Indian Constitution. If you look at articles of Indian Constitution, what are the major fundamental constitutional bodies? You have Finance Commission, Election Commission, UPSC, SPSC, National Commission for SCs, National Commission for STs, National Commission for BCs, and then you have GST Council, you have COG, Comptroller and Auditor General, Attorney General, Advocate General. And then you have Special Officer for Linguistic Minorities, which is a constitutional body. Again, for minorities, you have this. So GST Council is the latest one that they have added here. So these are some major constitutional bodies that we have as far as the Indian Constitution is considered. So the one question that they asked is the first one, National Commission for BCs. Yes, this is a constitutional body according to the articles of Indian Constitution. So the answer is only one. Next, the next question deals about the special privileges of President and Governor. If the elections of the President of India is declared void by the Supreme Court of India, all the acts done by him or her in their performance of the duties of their office before the date of decision becomes invalid. So what they are saying, if the elections of president, say president is elected, later on it was said that he was disqualified. Whether the acts committed by the president up to that time will become valid or not. Yes, this is a simple provision that they will be valid. They are not going to be invalid. They are not going to be invalid. Elections for the post of the President of India can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. Now, this is not present. If you look at this, what they are saying, have a look at it. So, what is the Electoral College of President? In order to have elections, you have an Electoral College. Now, what is the Electoral College of the President? All the elected members of Lok Sabha, Rajya Sabha, and elected members of state legislative assemblies, along with the union territories of Jammu Kashmir, National Capital Territory Delhi, and Puducherry. So these are elected representatives. They should be elected representatives. Now, say for example, president elections are going on and some state legislative assembly was dissolved. Whether elections can be postponed or not. Constitution clearly says that there is no requirement of waiting for the state legislative assemblies to convene so that presidential elections have to be held. Because in India, every year, at least year on year, every year, some states will be going for elections. Now, if you consider that, it is very difficult for elections of president to happen. So, given the context of India, what Constitution of India said that even if the so-called elections for the post of President of India can be postponed, no need to be postponed. No need to be postponed. Constitution says that there is no requirement. When a bill is presented to the President of India, the Constitution prescribes time limits within which she has to take a decision. There is no time limit. That is called pocket veto of President. So, Constitution does not to prescribe the time limit. They cannot be postponed and invalidated. They cannot be invalidated. So, they are asking how many of the above statements are correct. None of the above statement is correct. None of the above statements are correct. So, the answer for this question is D. With reference to finance bill and money bill in the parliament, consider the following statements. Now, ladies and gentlemen, understand very simply I am saying this. Finance bill and money bill. What are the differences? Money bill contains the provisions that are there exclusively in Article 110. And finance bill, majority of the books will write two divisions. Money bill category A, category B, or money bill 1, money bill 2. So there will be finance bill 1, finance bill 2. There is no requirement of having these two divisions. Just remember what is the procedures. Money bill can be introduced only in Lok Sabha. Money bills cannot be introduced in Council of States. This is first provision. Money bills are not required to be introduced in Council of States according to Article 109, which speaks about special provisions in order to pass the money bill. Second one, Rajya Sabha can discuss money bill matters, can suggest changes, but they cannot amend themselves the money bill provisions. Cannot amend themselves. Third one, Speaker of the Lok Sabha will have the final power to decide whether a bill is money bill or not. Fourth one, when the money bill goes to the President of India for his consultation or for his assent, President either has to reject or has to accept the money bills. He cannot return the money bills. This is what we have as far as money bills is considered. What about finance bills? In the procedure of introduction, in the procedures of introduction, money bills and finance bills are same. Now, what do I mean by this? They can be introduced only in Lok Sabha. Except introduction, the rest of the provisions for finance bill is same as normal bill. So what do I mean by rest of the provisions are same as normal bill? Finance bills, Rajya Sabha has equal powers on par with Lok Sabha. President have all the powers of acceptance, rejectance, return or withholding. President can do anything on the finance bill. So what is the difference between finance bill and money bill? The only difference is, except in the introduction part, in the rest of the things that is different. In the introduction, a finance bill has to be introduced in the same process just like a money bill. But when you are passing the finance bills, it will be having all the provisions equal to that of the so-called a normal bill. The next one is whether if money bill is not passed, can there be a joint sitting under Article 108? No, there cannot be any joint sitting because Lok Sabha has higher powers compared to Rajya Sabha. But finance bills, yes, they can have, because it is an ordinary bill once it is introduced. They can have joint sitting under Article 108. What Article 108? If the president may feel that he has to call for a joint sitting, he can call. So it is president's discretion to call for joint sitting or not, because constitution uses the term may call for the joint sitting. So this is the thing that we have to understand in order to understand that question. Now have a look at that question. With reference to finance bill and money bill in the Parliament of India, consider the following statements. When the Lok Sabha transmits the finance bill to the Rajya Sabha, it can amend or it can reject the bill. So when the Lok Sabha passes this to Rajya Sabha can amend or reject the finance bill. Finance bill, it has equal powers just like an ordinary bill. Yes, Rajya Sabha can do it. When the Lok Sabha transmits money bill to Rajya Sabha, it cannot amend or reject the bill, but it can only make recommendations. Yes, this is the major provisions of money bill and finance bill. In the case of disagreement between the Lok Sabha and the Rajya Sabha, there is no joint sitting in money bill, but a joint sitting becomes necessary. It is saying that it becomes necessary. No, there is no necessity. Article 108 joint sitting itself is not necessary. It may, president may. So it is discretionary power of president. So this is not necessary, but if president wants, he can keep it. So this is wrong. So third statement is wrong. First statement is correct. Second statement is correct. So how many of the statements are correct here, ladies and gentlemen? Only 2, 1 and 2 are correct here. Moving further. With reference to scheduled areas in India, consider the following statements. Within a state, the notification of an area to be scheduled area takes place through an order of president. Now, who will define an area as scheduled area? Yes, president has to notify it, and yes, president of India has to notify an area as scheduled area. The largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of villages in the block. So they are saying the largest, with reference to scheduled areas, largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of villages in the block. The Chief Minister of the concerned states are required to submit annual reports to the Union Home Ministry on the administration of scheduled areas and tribal areas. So we'll come to the second point first. Let us look at this Chief Minister provisions. So whose duty is to submit an annual report? Duties will be for President or the so-called governor, normally, to present it to Parliament, or governor to the President, or governor to the so-called Parliament, like this. It is the duty of governor, not the President, to do it. So third statement is a simply wrong statement. First statement is correct statement. Now look at the second statement. The largest administrative unit forming in a scheduled area is the district, and the lowest is block. In the scheduled areas, the system of administration will be, the largest will be the district, the smallest will be the block. So this you have to remember. So two statements are correct, 1 and 2 are correct here. 1 and 2 are correct. First statement is correct, second statement is correct, third statement is wrong. Moving further. So only two are correct. Consider the following statements. Statement 1. The Supreme Court of India has held in some judgments that the reservation policies made under Article 16, Clause 4 of the Constitution of India would be limited by Article 335 for the maintenance of administrative efficiency. If you look at Article 335 special provisions regarding to Constitution clearly prescribes that yes, reservations can be provided for the so-called scheduled caste, scheduled tribes, provided that you are not compromising on the administrative efficiency. This was the term that is used in Article 335, hence first statement is correct. Article 335 of the Constitution of India defines the term efficiency of administration, defines the term. We have to be very, very careful. Constitution defines it. Majority of the areas, Constitution will not define what is it. Constitution just says what are the provisions. It will not further define what is the so-called administration of efficiency of administration. Constitution does not define it. It is up to the court jurisdiction to look and interpret it. So second statement is wrong, first statement is correct, and we have to be very careful when they are saying that Constitution is defining it. So the answer for this type of questions will be statement 1 is correct, but statement 2 is incorrect. So Constitution defines is wrong. Constitution defines is wrong. Next, with reference to Home Guard, consider the following statements. Home Guards. Home Guards are under the Home Guards Act and rules of the central government. Now, Home Guards work under the state government, not under the central government. So, this is again a subject matter. So, this is wrong. This is a wrong thing. So, Home Guards are raised under the Home Guards Act and rules of the state governments. The role of the Home Guard is to serve as an auxiliary force to the police in the maintenance of internal security. Yes, it helps the state police to maintain the so-called internal security. To prevent infiltration of the international borders, coastal areas, the border wing Home Guards battalions has been raised in some states. In some states, yes, in order to protect internal security, some border wing states or Home Guards or battalions have been raised. So this is correct. This is correct. First statement is wrong. If you observe carefully, second statement itself is saying it helps the police in maintenance. So police means not central subject, it is union subject. This is state subject. So the first statement is wrong. 2 and 3 are correct here. First statement is wrong. 2 and 3 are correct statements here. What is the correct answer? 2 and 3. 2 and 3 are correct statements. So only 2. Moving further, so Home Guards is raised under the Home Guards Act. Home Guards are voluntary force, so it is under the so-called state or union territories list. So the role of Home Guards is to serve as an auxiliary force. So these are the things. So 1 and 2 are correct here. Moving further, with reference to India, consider the following page. They have given some article rules, and they have said which article of Indian Constitutions or which act speaks about it. Unauthorized wearing of police or military uniforms. Now, say for example, in movies they will show that I am wearing military uniforms, police uniforms. You cannot go without permission. You have to take permission according to which act. If you want to wear military uniforms or police uniforms, it has to be worn according to the so-called Official Secrets Act. Yes, this is Official Secrets Act. Under Official Secrets Act, you have to take permission if you want to wear police or military uniforms. Knowing misleading of others, interfering with the police officer or military officer when engaged in their duties. So if you are misleading police or any investigative officers, this is going to be an offense according to which act? Again, this is according to Official Secrets Act. This is according to Official Secrets Act. So Official Secrets Act say that you should not interfere or mislead the authorities. At the same time, it is also saying that you should not wear these things as you like. Celebratory gunfire, which endangers the personal safety to others, is prohibited under the Arms Amendment Act. This is correct. So the answer is 1 and 3 are correct. Second statement is wrong. Second statement is wrong. So only 2 statements are correct here. Only 2 statements. What are those? 1 and 3 are correct. Moving further, Consider the following statements in respect of national flag of India according to the flag code of 2002. So according to flag code of 2002, what are the permitted flag sizes? One of the standard sizes of the national flag of India is 600 mm into 400 mm. Normally people will think 3:2 ratio. As a result, it will become correct. But let's look. The ratio of the length of the highest, that is height, width to the length to width should be 3:2. So this we know. The length and width of the ratio of the Indian national flag has to be 3:2. That everyone knows. But majority people think that 600 into 400 is also 3:2. Hence both becomes correct. But first statement is incorrect. But first statement is incorrect. There are some standard settings. As far as the national flag dimensions are considered in India. So it should be 150 into 100, 225 into 150, 450 into 300, 900 into 600, 1350 into 900, 1800 into 1200, 2700, 1800, 3600, 2400, 6300, 4200. So you remember one side, you'll remember the other. 100, 150, 300, 600, 900, 1200, 1800, 2400, 4200. These are the things that we have. Consider the following statements. India's public sector healthcare system largely focused. So the answer is, first statement is incorrect, second statement is correct. So only one option. So the answer for that previous question is statement 1 is incorrect, but statement 2 is, sorry, the answer should be this one. Statement 1 is incorrect, statement 2 is correct. Statement 1 is incorrect, statement 2 is correct, because you have standard defined flag codes here. Next, consider the following statements. India's public sector healthcare system largely focuses on curative care with limited preventive, promotive, and rehabilitative care. So look at this. What is prevention? What is curative? That you should understand. It is always said that prevention is better than cure. But whether Indian hospitals are making the people to be ensuring that they are preventing the disease or they're treating curative diseases. Most of healthcare in India, unfortunately, is focusing on curative medicines rather than preventive medicine. Prevention comes first. Then if you are affected with the disease, go for curation. But in India, Indians do not have this preventive measures, or there are lack of institutions which highlight the role of preventive medicines or preventive steps. So, majority of the public sector healthcare in India is limited to preventive, promotive, and rehabilitative care. Yes, this is correct. Majority of Indian health sector is focused on this. Under the India's decentralized approach to healthcare, the states are primarily responsible for organizing the health services. Yes, states are responsible for organizing health services, and much of the healthcare is in the promotive these things. What is the correct statement? Statement 1 and 2 are correct, and statement 2 is correct explanation of statement 1. Statement 2 is correct explanation of statement 1. So the answer for this question is A. Moving further. According to the Constitution of India, the central government has the duty to protect states from internal disturbances. Yes, Constitution clearly says that under Article 355 and Article 365, saying that it shall be the duty of the center to protect the state from internal disturbances. Constitution of India exempts. So first statement is correct. Constitution of India exempts the states from providing legal counsel to a person being held under preventive detention. Constitution of India exempts the states from providing legal counsel for persons under preventive detention. So, under preventive detention, you have to have your own legal counsel, and Constitution of India says legal counsel can be denied. According to the Prevention of Terrorism Act 2002, confessions made before the police cannot be used as evidence. This is what they are saying. So have a look at it. If you look at it, The Constitution of India, the central government has the duty to protect the states from internal disturbances. Yes, this is correct. The Constitution of India exempts the states from providing legal counsel to a person being held for preventive detention. Yes. Normally, if you look at Article 20, you have the right to seek the legal counsel immediately once you are arrested. But for persons who are under preventive detention, that provision is not there. According to the Prevention of Terrorism Act 2002, confessions of the accused before the police cannot be used as evidence. So this is wrong. If you are going to a police and if you are confessing before the police, that can be deduced as an evidence under the so-called Prevention of Terrorism Act, because terrorism is dealt more seriously and there is no requirement of judicial magistrate to listen to that case. So the answer is, third statement is incorrect. First statement and second statements are correct. So only two statements are correct. Only two statements are correct. Next, consider the following: demographic performance, forest and ecology, governance reforms, stable government, tax and fiscal efforts. For the horizontal devolution, 15th Finance Commission used how many of the above criteria as the population? So what are the criteria for 15th Finance Commission apart from population and income distance? Apart from population and income distance, what are the criteria? This is the criteria that you have to remember. 15th Finance Commission used the criteria of population, demographic performance, area, forest, per capita GSDP, income distances, tax and fiscal efforts, these things. 16th Finance Commission, latest one, have removed this and they added GSD, contribution to GDP. So this is important. 16th Finance Commission removed tax and fiscal efforts and they started adding contribution to GDP. But 15th Finance Commission, you have population, demographic performance, area, forest, per capita GSDP, tax and fiscal efforts. So this is the question that they are asking. Apart from population and income distance, how many are the things that we have in the questions asked? So demographic performance you have, forest and ecology you have, governance reforms you do not have, stable governments you do not have, tax and fiscal efforts you have. So 3 plus 2, 5 they have given here. So total there are 6. So the answer is only 3. The answer is only 3. That is the correct statement. Next, moving further. Consider the following statements in respect of elections to the President of India. The members nominated to either House of the Parliament or the Legislative Assemblies of states are also eligible to be included in the Electoral College. I just said no, that to the Electoral College, you will not have the so-called nominated members. You will not have nominated members. Higher the number of elective assembly seats, higher is the value of vote of each MLA of that state. Higher the number of elective assembly seats, higher the value of vote of each MLA of the state. This is wrong. Value of vote of each MLA. Value of vote of an MLA depends upon the so-called total population of the state divided by total elected members of state legislative assembly into 1 by 1000. So higher the number of elective assembly seats, higher is the value of vote of each state. This you cannot deduce. Next, the value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. The value of vote of each MLA of Pondicherry is higher than that of Arunachal Pradesh. Very, very difficult question or trivial question. So just recall this one. Just remember this. Look at it. The value of vote of an MP in presidential elections is based on the number of elected members in legislative assemblies and union territories, including Delhi, Pondicherry, and Jammu Kashmir. If the number of elective assembly seats increase, the value of vote in each MLA will decrease because it is in denominator. So statement 2 is incorrect. That is what we said. The value of vote of each MLA of Madhya Pradesh is 131, which is less than that of Kerala. Hence, statement 3 is incorrect. This is trivial question, very difficult question. The value of each MLA of Puducherry is higher than that of Arunachal Pradesh because the ratio of total population to total number of elected seats are Puducherry is greater as compared to Arunachal Pradesh. So statement 4 is correct and statement 1 is also a basic question. So what is the answer for this question? Only one is correct, which is the one. The members nominated are not eligible. This will be lesser. This is not asserted. This is also false. Last one is correct. So only one statement is correct here. Only one statement is correct here. This is what we have as far as the legislatures are considered. So this is 2023 question paper. This is 2023 question paper as far as polity is considered. So what is the summary? 2023 polity question summary. How can you summarize it? If you look at the summary, majority of the questions have been asked. Two questions have asked from president elections. They focused on procedures like procedure established by law, due process of law, constitutionalism, and they asked some questions based on some arms, flag codes, and then scheduled areas, tribal areas, powers and functions of president, governor, and then they asked some questions on constitutional amendments, and then they asked which are constitutional bodies, and then they asked some lists, state list, central list, concurrent list. These are the questions that they asked, which are regularly asked themes. But this year, 2023, you have some 2 to 3 questions which are off the hook. Like, take for example, home guards, where they will function, prisons, where they are present, and some arms dealings, right? Wearing of uniforms, and they have said which act has this. So, so in this 2023, polity questions are bit moderate. They are not neither too easy, neither difficult, but there are some difficult questions, there are some easy questions. So we can classify 2023 paper as a moderate paper. This is what we have as far as 2023 polity questions are considered. Keep tuned here. We'll be coming out with 2022 question paper also. Thank you, ladies and gentlemen. Wish you all the very best. Take care and subscribe to UPSC Preplab. See you. Take care, guys.